Hi everybody, I'm live. It's Elizabeth Mathern from Kuck, Baxter Immigration. I'm gonna give people a few minutes to join. I'm actually not in the office today. Kuck Baxter on the road to Jacksonville USCIS office. I had an interview there today, so you won't have that lovely brick wall behind me, but I wanted to, keep my appointment with you guys and let's talk about what's going on in the world of immigration. So feel free to post where you are, hello, put those likes and those hearts and anything else that you want to put, those bubbles to come up. That alerts more people that we're on, so more people can hear this good news, good information. And I'm in Jacksonville, so the signal should be strong, unlike in rural Georgia where it's a little bit spotty. I know sometimes my lives kind of, what do my kids call it, like glitch because the internet isn't great there. We're hoping for broadband in rural South Georgia. But anyway, we've got a good signal here in Jacksonville. I really like coming down to this office, so it's a pretty good office. It's a smaller office than the Atlanta office, but I think it's pretty easy to deal with. So just today, I want to talk about just some basic immigration news, stuff that's going on. We don't have any answers on the immigration reform yet. I was just scouring Twitter and all the news outlets. Congress is putting up, or the Senate is putting up a Plan C. Who knows? Who knows what's going to happen with that? I think a lot of people are feeling a little bit less than optimistic that the Democrats will be able to pull something off. I'm gonna continue to try to stay optimistic because that's the space I like to live in. Maybe something can get done. I think that could also be called gullible, but we'll just have to see. A lot of people are trying to hold the administration accountable for the promises that were made during the elections, but we know politicians make promises all the time that they don't necessarily keep. So we'll be waiting, watching, stay tuned. I think you guys have heard about the fully vaccinated individuals, the travel restrictions are loosening, that the travel on the Mexico border for ferries, I think it's ferries, trains, buses, and like the carport of entries, that's going to be lessened a little bit for people with visas. And I think that was for essential travel. Non-essential travel, just like vacations and stuff, was not relaxed. So that's that. I think everybody probably heard last week I talked about Hong Kong DED, which is deferred enforced departure. That gives people some protection if they're from the Hong Kong residence, if they have Hong Kong residency. Let's see, I see a few questions coming in. Like I said, I'm on my mobile, so I'll do my best to catch your questions. Let's see, we've got some people asking about DV. So DV 2020, make sure you follow Mr. Kuck on Twitter for those updates. I know that I saw a motion to clarify the judge's order was submitted on that. So I would just stay tuned for news on DV 2020. I think that USCIS can do anything they put their minds to, as far as processing those visas, but it seems like they have a whole lot of money in filing fees and a whole lot of excuses for why they can't move applications. So let's see what the federal judges do on that. DV 2021, I think we're in the same boat, trying to see how USCIS is going to interpret the order that the judge issued, and we're still waiting for that guidance to post from them. I haven't seen it post. I haven't heard anything about that posting. What else? So there's not a ton of immigration related news today. I mean, the big thing hanging in the balance is the will this immigration reform happen? If this Plan C will be processed by the parliamentarian or approved by the parliamentarian. And if not, what are the Democrats willing to do about it? Will they fire her? Will they get a new parliamentarian? That's yet to be seen. So, I mean, it makes for, I guess, the media and news outlets seem to like to carry the drama, but I don't know if we're getting like a lot of really good information from what is actually happening. It sounds like there's also just a framework, that there's not actually a bill happening right now. So anyway, we'll see. Another thing I would like to talk about, if there's no other questions, is I'd like to explain to you guys today about the removal of conditions, the petition to remove conditions. So some of you may know that if a person is married for less than 2 years, when their spouse petitions for them, that's either a lawful permanent resident petitions for a spouse or a U.S. citizen petitions for a spouse and they haven't been married for very long, they will only get a 2-year green card. That's called a conditional permanent residency. And they have to file the Form I-751 within a certain period of time. And if that is granted, then they get their full 10-year green card and they are lawful permanent residents. If they don't, then they are looking at being put in removal proceedings and trying to fight to stay in the U.S. So I want to talk a little bit about what the 751 is and what are the grounds you can ask for it to be granted. So I'll get to that in just a second. Let me see. I see a few questions. Let's see, Pierre. Hi, Pierre. Thanks for asking a question. Thanks for watching. I love doing this on my mobile because I can see all the people that are watching. So thank you so much for tuning in. All right. So Pierre says, those who live out of the country that are residents and only come to work and contribute for 3 months and the rest of the year receive unemployment living out, they need to take care of their green cards and give it to the ones here. Well, Pierre, that's a very interesting point. Lawful permanent residents are required to live in the United States for at least 6 months a year. And remember, unemployment income is based on what you pay in. So it's actually unemployment insurance. So you pay into a fund for unemployment insurance based on your wages. So I'm not sure really what you're getting at there, but I do understand that people who are here want permanent residency too. Yeah, I understand that for sure. And I can sense a little bit of frustration in your post, so I'm sorry about that. So let's get back to conditional permanent residence. And I'll just say real quick for those of you just joining, my name is Elizabeth Mathern with Kuck, Baxter Immigration. I am in the South Georgia office, which is in Adel, Georgia, which is halfway between Tifton and Valdosta, right off I-75. I am on the road today to the Jacksonville USCIS office for an interview. So I figured I'd just do my Facebook Live on the road. So here I am. Okay, so I wanted to talk about conditional, it's called CPR, Conditional Permanent Residency, Removal of Conditions. So that is a Form I-751. And if you want to look it up yourself, in fact, I encourage you to look at the statute. It's all laid out there in the statute. You're more than welcome. Don't trust me. Look at the statute. That's what we always do. So it's 8 CFR 1216.5. And you'll see there outlined a few bases for filing to remove conditions. That's to take you from the 2-year conditional permanent residency card to the 10-year residency card. Okay? So you can jointly file that. If you're still with the spouse that petitioned for you, you guys file it together. You show proof that you are still living together, commingling of funds. And the whole basis behind, my understanding behind this statute is that USCIS, or I don't even think it was USCIS at that point, the government decided that 2 years was a good period of time to be able to see if marriages were real or not. I think they just, maybe there was some studies done, and statistically that was the amount of time that fake marriages couldn't last anymore. So they created this additional step for people who hadn't been married very long. So sometimes when you get that conditional green card, you haven't been married very long, or the person didn't have any, the non-citizen didn't have any, or a foreign national spouse didn't have any documentation really to be able to get on bills and stuff. Maybe it was hard for them to gather much proof of cohabitation or commingling of funds. But at the I-751 step, they're going to be looking to see if you have proof of that. So like cohabitation, meaning proof that you're living together. Commingling of funds, meaning that you're sharing the same like household pot of expenses, same household income is all being shared and mixed together to pay for the joint household. Also, they'll look at, if children were born during the union. That can be really kind of a antiquated thing to look at, because there are lots of relationships that don't result in children. And it does say like children born in, I think in the statute it says children born during the relationship. So, that's not really in keeping with modern families. So anyway, that one feels a bit out of date and probably should be updated. All right. So the joint filing, it's complicated to gather all those documents, but that's, I think, a little bit more of the easy scenario. The more complicated scenario is if the spouse is split. So that means that the foreign national spouse needs to self-petition for the conditions to be removed. And there are different bases for that, right? And you can look in the statute to see those bases. One that I think a lot of people know of is the marriage was in good faith, but it ended in divorce. Okay. There's another two that a lot of people don't know a ton about, and that's that the marriage was entered into good faith by the conditional resident, the CPR, the conditional permanent resident, but they were subject to battery or extreme cruelty by the U.S. citizen or lawful permanent resident spouse. Through no fault of their own, the relationship was terminated. So in that statute, they list different types of evidence that they expect with that reason for filing for the waiver. And that includes similar documents to what I just described, right? Proof of joint assets and liabilities during the marriage, etc. But it also lists that, oops, sorry, my hand shifted. It also lists that you may include proof of any threat or act of violence, physical or mental injury, psychological or sexual abuse or violence, exploitation, rape, molestation, incest are specifically named in the statute. Or, let's see, the other thing I didn't say is extreme cruelty or abuse to the conditional permanent resident or a child. The status of the child does not matter under this statute. So the child could be a child with no status. The child could be a citizen because they were born here. And that would still, even if the conditional permanent resident was not necessarily abused, if they witnessed the child, who's a U.S. citizen, being abused or treated with extreme cruelty, such as molestation, things like that, then the conditional permanent resident themselves would have a basis for the joint filing, the waiver of the joint filing under this waiver statute, okay? Now, the one thing that's really important to know is the statute says you may submit all sorts of evidence, right? Like affidavits and stuff like that. But it says you must submit an evaluation by a qualified professional. So it has, and it lists social worker, psychiatrist, psychologist, or other service providers that are approved by USCIS. So if you are going to go the route of extreme cruelty or battery during the conditional residency period, then you must get an evaluation done. There are lots of service providers that have sliding scales. And you will also, if you are looking for somebody to do an evaluation, there are certain professionals, mental health professionals, that know and understand the immigration process and are probably a little bit better poised to write that evaluation because they kind of understand what it, like the point of what you're submitting the evaluation for, so that it's not kind of like just all over the place. They know how to target it a little bit more. And then of course, there's a third basis for waiving the joint filing requirement. And that's one that a lot of people, I don't see people use it very much. I think it's hard, but it's an interesting part of the statute. So it's actually the first prong on the statute, that deportation or removal would result in the conditional permanent resident suffering extreme hardship. So extreme hardship is similar to what we talk about with like cancellation of removal, things like that. But if you notice in that statute, it does not mention that you have to prove that the marriage was in good faith. So say, for example, that a person was in a extremely difficult relationship and was not able to leave or have any documentation through one reason or another. I can think of multiple reasons that I've seen. To not have any documentation of commingling of funds or cohabitation. They're not able to prove the good faith marriage necessarily. But they can prove extreme hardship. So what does extreme hardship look like? Sometimes we're looking for something that arises during the conditional residency period, which may be like a medical condition, mental health concerns that wouldn't be treated or treatable in their home country, some sort of physical injury or ailment that makes it difficult for them to that would make it difficult for them to start over their life in their origin country. So if they were removed or deported, or if they have potentially like children, what sort of hardship it would be for them to maybe try to raise their children in their home country. So there's a lot of different directions that we can go there. You don't have to have a qualifying relative for this extreme hardship like you do in other waivers, right? Like cancellation of removal, for example. You have to have a U.S. Citizen or permanent resident, parent, child, or spouse. In other waivers like the 601A, they can only look at the hardship to the parent or spouse, etc., right? Most waivers have some sort of qualifying relative. In this particular prong, there's no qualifying relative required. So it's a really good option to look at, and I think we sometimes maybe overlook it. I don't necessarily, but sometimes we as a collective, people in general, overlook it. So it's a really, really important, I think, option for people who need to file their conditional permanent residence, removal of conditions for their CPR. Okay, so what if you like didn't file it, or you filed it late? I have this one crazy little hair. You filed your you haven't filed your I-751 on time. What does that mean? Does that mean that you're just in really big trouble? Don't wait. Like, don't wait any longer. Stop the bleeding, basically. You need to file it. You can request like that your late filing be excused and give a reason why. So don't hesitate. Like, get it done, even if it's late. Okay, I know I've seen a lot of people in the time I've been doing this work that missed that window, maybe because the relationship was really volatile, maybe because they didn't have the money with COVID and everything. I know a lot of people have gone through hard times, so they put it off, and then they feel scared about filing something, or they think that there's no option to file it late, like, oh, that ship has sailed. It hasn't. You need to file it, and that way, you know, it's done. We can help you with that. Also, what if your I-751 gets denied? What happens? So in the statute, it talks about how the officer should refer you to immigration court. What does that mean? That means that the immigration judge would get to look at your petition with fresh eyes. So it's called de novo review. That means you get to present witnesses, you get to present like testimony, you get to present additional documents, you get to testify. Anybody else that you want to testify can. I once had a couple who had been married like 27 years prior, and they had only been married for, I think, like 6 months, and my client's ex-wife came and testified. They talked about, you know, the marriage, and they were cross-examined. Both parties were cross-examined by the government attorney, and the judge asked questions, and we ended up getting that granted. So, you know, these are really challenging, but they're not impossible. Another option, if your I-751 gets denied, is you can, even if you're in front of the immigration judge and you have a court date, you can file a new I-751 with immigration if you file under a different ground. So let's say that you filed under one of the grounds that we talked about, but you didn't check the other boxes, but they relate to your case. In order for us to have all of the arguments in front of the judge, we would want to file a new 751 in front of immigration. Immigration has what's called initial jurisdiction, so they have to be given the first chance to review it. We call it kind of like the first bite at the apple, and then the immigration judge gets the second bite at the apple. So that's that. That is the I-751 process in a nutshell. Let me scroll really quickly through and see if I missed any questions. Thank you so much, everybody, for watching. Let's see. Okay, I answered about DV 2020 and DV 2021. And I think, oh, what happened with Daca? Sicarius, thank you for asking. Daca is still hanging out. Where we are now is renewals can still be processed. Initial applications are on hold. The Biden administration is trying to codify or put into law something that is similar, or actually I think it was exactly the same, so that it would be a regulation, I think is the right term, a regulation, and would be like written into the law instead of being so fragile as an executive order. That comment and notice period, I think, goes through November 29th. And then we've heard that Plan C with the immigration reform may include some sort of Daca expansion. If you follow Mr. Kuck on Twitter, or you watched yesterday's Facebook Live, Mr. Kuck mentioned about how people who would qualify for Daca, like the last group of people who would qualify for Daca, are about to turn 15. So that would be the last group of people who were physically, would have, in theory, have been here in the US in 2007, and are now turning 15 next summer. So, you know, it's kind of frustrating that there is a whole group of people left out from that. So we are just watching, Lucas, we are just watching. We're watching to see if this immigration reform package, if it makes it in, is going to do anything to expand Daca or make it more solid. Remember, the case is still pending out in Texas. In theory, the judge there could issue some sort of a ruling any day now. Let's hope not. Let's hope that just stays on ice and something gets put into law before that. So, you know, advanced paroles for Daca holders are still being processed. Renewals are still being processed. Initial filings can, in a technical way, can still be filed, but they will not be processed. So you might as well, if you have not filed an initial, you need to talk about a lawyer with whether or not you want to take that risk and file that. They said that they would be accepted but not processed. So I don't know. You run the risk of losing your filing fees and also giving the government your information when they may not have your information at this point. So, all right, folks. Well, I think I'm going to wrap up. I'm going to drive back to the office. Thank you so much for joining, and I enjoyed seeing all of you on here today. So many of you watching. That's super cool. And I don't see any more questions, so I'll sign off. Again, this is Elizabeth Mathern from Kuck Baxter, South Georgia office. I am in Adel, Georgia. Usually you see that pretty brick wall behind me. We're in a 110-year-old building that was refurbished in downtown Adel. It's really quite beautiful. What was done to the building, it used to be like an old grocery store or something. So come see us. Our number's in the comments, 229-472-5775. Be happy to talk with you, talk about your case. If you have anything related to an I-751 that we talked about today, you want to ask questions or you want to see what can be done in your case, I would love to speak with you about them. I've done quite a few of them in my career and really enjoy that, helping people in that situation. Okay, Henry Atkins, before I jump off, let me read your question quickly and see if we can answer it quickly before we go. Oh, okay. Do you know if the consulates in South Africa will stop canceling appointments now that travel ban has been lifted? We have an L1A and an L2 visa appointment scheduled for February 20, or you must have had a appointment scheduled for February of 2021, our 10th appointment. Do you mean February 2022, Henry? 10 appointments. I do not have any intel on whether they're going to stop canceling appointments. As most of us have talked about, like, it's extremely frustrating to watch what these consulates are doing right now. With all the travel restrictions being lifted, pretty much a lot of things are back to normal. Yeah, I don't have any intel, but I really hope for, like you say, I hope it won't be canceled and you'll be able to process that. All right. Well, my prayers are with you, Henri, and let us know what happens. Okay, folks, I'm going to run. Have a great rest of the week and a great weekend. Take care. Bye.